wonder if there was ever going to be.
Justice Breyer, Baroness Ainley, my lords, ladies and gentlemen, welcome to you all to this 60th anniversary lecture. It's the 60th anniversary lecture in London. I say that because this is one of a series of lectures. The first was in Cardiff in October when Professor Melton from Harvard University, who's a leading stem cell research scientist, spoke at Cardiff about that. By the way, the Chancellor of Cardiff University is a Welshman who was a Nobel Prize winner in stem cell research, so there was some synergy. We're very pleased to have Justice Breyer here this evening for what will be the second lecture. The third lecture will be in a few weeks' time in Belfast, in Queen's University Belfast, where Anne Applebaum, who is a world-renowned journalist and Pulitzer Prize-winning author, will speak. And then later this year in Edinburgh, Dr. Dan Yergin, energy expert and also a Pulitzer Prize-winning author, will speak on energy in Scotland. This all shows the devotion that very senior people in the United States who have Marshall Scholarship on their CVs, who've lived in the UK, are able, willing to come back to the UK to celebrate this 60th anniversary. And if I may say so, Justice Breyer, we're very, very grateful for your presence here today. Could I also thank the FCO for continuing to support the Marshall Scholarships, for making these wonderful rooms available to us today, and particularly to Baroness Ainley, who is possibly the only functioning minister in the Foreign Office at the present time. So the weight of responsibility, Baroness and Minister, is quite heavy. Thank you very much for being with us tonight. And finally, and not least, to thank DLA Piper, who have helped sponsor this series of 4 lectures. Let me also give a little outline. Many of you know the Marshalls, and of course you will know them better by the end of the evening, because the cohort of Marshall Scholars are here. I don't know how you distinguish them, except they're rather younger than the rest of us, but please, let's look forward to you all meeting the Marshalls for a drink afterwards. The other more elderly members, if you forgive me for saying so, to the right and the left, who are members of the Commission, the Marshall Aid Commemoration Commission, they are, like me, we're all publicly appointed volunteers, and we come from academia, from business, and from the public sector. And our job is to run the Marshall Scholarship Programme with the help of 2 very dedicated members of our Secretariat, Mary and Lizzie. We work not on our own, but we work in cooperation with the FCO, with the US Embassy, and we're very glad Elizabeth Dibble is here today, the Deputy Chief of Mission of the US Embassy. And with our own embassy, naturally, in Washington, and with the Consulate General Network. Because at the heart of the Marshalls is not just government to government, it's volunteer to volunteer. We have selection committees throughout the United States, and those are volunteers, US citizens, who together with the Consul General choose the Marshalls who come to the United Kingdom. And it's not just there, we have an association of Marshall Scholars. I'm being corporative here, the MAC and the AMS almost work together. So the Association of Marshall Scholars is a great organization. It's probably unique in terms of the scholarship programs that the FCO has supported to have such a strong association of Marshall Scholars. Fine. Let me explain the running order for the events this evening. Justice Breyer has kindly agreed to present a Marshall Medal to Lord Hannay of Chiswick. Thereafter, Baroness Ainley will introduce Justice Breyer. He will then give a lecture. I've been given this hard and stern task of moderating the question and answer session, and I will be quite ruthless towards the end because we will be going in there for a drink. So I shall be very serious about doing that. We don't want to spend too much time with me talking. Can I just now begin the medals ceremony, Lord Hannay, by indicating that Marshall medals are awarded, not very frequently, to individuals of outstanding achievement, whose contribution to British-American understanding, distinguished role in public life, or creative energy reflect the legacy of General George C. Marshall and Marshall Scholarships. Medals have only been awarded to mark the 50th and 60th anniversaries of the scholarship. The Right Honourable Lord Hannay of Chiswick will be the 14th recipient, and others who have received this medal include Justice Breyer, who received his some 10 years ago. The citation for the medal is as follows. Lord Hannay is honoured for his long-standing contribution to British-American relations through his very distinguished career in the British Diplomatic Service and his ongoing support for the Marshall Scholarships Programme. Lord Hannay was made a life peer in 2001. He is a member of the Council of the University of Kent and a member of the United Nations Secretary-General's high-level panel on threats, challenges, and change. If I could ask Lord Hannay to come up and Justice Breyer. Over to you, Minister.
Good evening, and I'm delighted to be able to host this event tonight. I know I'm not the last Foreign Office Minister standing, I do assure you. The others are resilient and they're making sure they not only keep the country safe, but also trying to keep their seats safe as well by trying to be re-elected. But I am particularly glad to be able to be here on behalf of the FCO in support of the Marshall Aid Commemoration Commission, better known as the MAC, or better known to you as the MAC. It was a new acronym to me, I have to say. I've always used a rather long title before. So tonight, as we've heard, we're here to celebrate the 60th year of the MAC, and particularly to listen to Justice Breyer's thoughts on the United States Supreme Court. 70 years ago, ours was a continent torn apart by war. To this day, we are very conscious of the sacrifices made by the American people for peace in Europe. The Marshall Plan, which rebuilt our decimated economies, was bold and enlightened. The MAC was established after the war by the British Parliament as a gesture of thanks to the people of the United States for their support. While the number of people that can remember World War II naturally diminishes every year, this country's gratitude to the United States of America endures and will endure. Our gratitude to the Marshall Commissioners, whom I met tonight, MAC's US regional selection boards, and the MAC alumni is similarly heartfelt. Your work continues to strengthen the deep ties between our two nations. Winston Churchill said that we're two countries separated by a common language, but our common values unite us rather than divide. Our Foreign Secretary recently told American diplomatic leaders that our relationship is special because we make it so. I could not agree more. This year we're celebrating on both sides of the Atlantic the 800th anniversary of Magna Carta, the cornerstone of individual liberties that both our countries protect and enjoy. In the UK, in the States, and in British embassies around the world, people this year will be remembering Magna Carta and the role it's played in the evolution of our democracies to the present day. The United States Supreme Court first cited Magna Carta in an 1819 opinion by Justice Joseph Story, who wrote that Magna Carta represented the good sense of mankind, that individuals must be free from the arbitrary exercise of the powers of government. Since then, the Supreme Court has cited Magna Carta over 100 times. The monumental bronze doors of the US Supreme Court building show an image of King John sealing Magna Carta in 1215. This document, 800 years old, is a living, breathing part of the American justice system today. So our countries share strong ties of history, of traditions, of values. But there's no excuse for complacency. As General George C. Marshall wrote to the first Marshall scholars back in 5th of October 1954, a close accord between our two countries is essential to the good of mankind in this turbulent world of today. And that is not possible without an intimate understanding of each other. True. Today, we celebrate the continued growth of that understanding between our two nations. We celebrate the work and achievements of our Marshall scholars. And I'm very much looking forward to hearing from Justice Breyer, and of course, a very distinguished Marshall scholar himself. But during his progress to the very top of the American legal world, he's always retained a deep commitment to education, serving as assistant professor, professor of law, and lecturer at Harvard Law School, as professor at the Harvard University Kennedy School of Government, and as visiting professor of law in Sydney and in Rome. President Clinton nominated Justice Breyer as an Associate Justice of the Supreme Court, and he took his seat on August the 3rd, 1994. Justice Breyer, we are delighted to have you here with us this evening, and I know everyone else here, very much looks forward to hearing from you. Justice Breyer.
Thank you, Lady Annalay. Very, very, very nice introduction, and Lord Hannah, and thank you, John Hughes, for your part, and also Mary Denyer, who had really organized all this. But I don't know why he didn't say that it was difficult to distinguish the Marshall scholars. The Marshall scholars are distinguished. That's why they're here. And so I really wrote this and for you. I mean, that's who I'm talking to. Because you're the ones who have to benefit or not benefit from what I'm going to say. But there's a little bit of nostalgia in it. And I begin by repeating the very same quote that you had, Lady Annalay, because it's a very good quote. And it's true. It was 68 years ago. It was at Harvard, and it was after a terrible winter of the 1947 winter in Europe. And General George Marshall, then the Secretary of State and Defense and everything, pointed out that Europe must have substantial additional help or face economic, social, and political deterioration of a very grave character. He was certainly right. He added the United States should do whatever it is able to do to assist in the return of normal economic health in the world. Right again. And that was the Marshall Plan. And it's good to remember that. The plan involved not just an economic transfer, but a call for international cooperation. It was intended to assure political stability and peace. 6 years later, Great Britain established the Marshall Scholarships. We're a small part of that, you say. Those scholarships were both a tribute to George Marshall and a kind of thank you for America's Marshall aid. The tribute was well-deserved, and Marshall himself understood the practical value of thank you. I mean, that's one thing the Brits understand. They do, and they're very good and quite right. He wrote to the first group of 12 Marshall scholars, "A close accord, as you said, between our two countries is essential to the good of mankind in the turbulent world of today," right? "And that is not possible without an intimate understanding of each other," which is difficult, but we achieve it. These scholarships point the way to the confirmation and the growth of the understanding which found its necessity in the terrible struggle of the war years. So, along with 1,400 other Americans, I personally have benefited from that tribute, that generous gesture of goodwill from Great Britain to the United States, and like those others, I should like in return to say thank you. Thank you for the Marshall Scholarship. It has made an enormous difference to my life. You have to remember, in 1959, that's when I came here. It wasn't actually the Middle Ages, but it was close. In 1959, we young American students didn't know all that much about foreign places, about history, about what we shared with those abroad. My idea of a really exciting foreign visit was my father taking me with him. I grew up in San Francisco, and sometimes he took me on the Southern Pacific Daylight Special or overnight on the Lark from San Francisco to Los Angeles, which is a very strange place in the 1950s. Well, in any case, you see the point. Now, when it came to knowledge of history, I was rather like the young boy who walked with his father, I think he's real, past the statue of Wellington on horseback in Hyde Park. Have you seen it? Well, there he is. All right. "Who's that?" the young boy said. "What?" His father said. "You don't know Wellington? It's Wellington, who led our country to victory against Napoleon, who defended our island, who saved our liberty." "Oh, I'm sorry, Father. I'm sorry." And he went up. He said, "Wellington, Wellington, I promise I'll never forget you. I'll never forget you, never, I promise." "Any more questions?" said Father. "Yes," said the little boy, I do. "Who is the man on Wellington?" Now, our knowledge of the world, I'm afraid, left something to be desired too. And I keep thinking, I once heard, which I use it sometimes in a talk, George Bernard Shaw advised a judge. The judge said, "My God, I have to give a talk in 20 minutes about everything I know about law. How am I ever going to do that?" And Shaw said, "Well, speak very slowly." He said, So we learned. We didn't learn everything. Despite Joanna, who is an English woman, my wife, I still haven't learned the English language, she reminds me. All that well, anyway. I take the tube, I see a sign that says, "Mind the Gap." I think of a clothing store. Here we are. And I still don't. What in heaven's name do we do with the sign in Piccadilly Station? It says, "Let people off first." I mean, who comes second? Bears? I mean, I don't understand it. But we learned. We Americans did learn. We learned by making friends. We learned from travel during vacations. We learned what we were taught formally, philosophy, politics, economics in my case. We learned beneath those dreaming English spires about a commitment to clear, critical thought, to seriousness of purpose. We learned about traditions of human liberty that run back at least to the great charter signed at Runnymede. We learned about public service and about democratic government. Richard Neustadt, who taught at Harvard for years about the presidency, told me much later that President Kennedy and Prime Minister Macmillan met in Bermuda about something you won't know about even, but I did at the time, the Skybolt missile. And after they met, they were talking informally about government and their business and what they were doing, and Macmillan described his plans for the next budget. Now, Kennedy, who had been struggling with Congress, said, "Well, what will Parliament do?" Macmillan, "What?" said Prime Minister, he said, "What? Parliament? Parliament? But we have a majority." He says, "They'll just pass. We recommend they pass it." "You recommend it? They pass it?" Kennedy said. "My God," said Kennedy, "anyone could run a country like that." Well, I mean, not quite, but still. We found that Britain, without a written constitution, had internalized the underlying principles of democratic government: rule of law, protection of individual freedom, participation in the public life of the community, giving them life, those principles, embodying them in the community's expectations of proper public behavior. We found that those underlying principles And those shared expectations simply resonated with our own experiences growing up on the other side of the Atlantic. And we found that while much was different in Britain, much too felt familiar. There was, at that time anyway, a kind of shared idealism, a certain sense of common history, of shared values, of shared objectives. Others, of course, might have found those same things elsewhere, but in my own case, they appeared at a particular place in England, at a particular time, among the teachers, the fellow students, and friends I made there. And that explains a little bit why I felt so touched when we were at the State of the Union message, at the State of the Union speech that the President gives, and my court was sitting there, and we look up, and there is Tony Blair, the Prime Minister of Great Britain, just after 9/11. And everybody stood up, including the judges who never stand up. Everybody stood up and applauded, and I felt, great, great. And it explains why those words that you quoted, Lady Henley, still resonate in my mind. A close accord between our two countries is essential in the turbulent world of today. Now, those words resonate for another reason. 60 years after the Marshall Scholarships were created, we live in a world that is no less turbulent than it was in George Marshall's time. That's your world. The interdependent world of today is characterized by many things. Among them are a fragile international economy, we've learned, growing economic divisions between North and South, increased environmental risks, insecurity, and in some places, anarchy, fanaticism, and terrorism. How do we solve this? If there's any hope of solving such complex problems which belong to no one nation, the effort will have to be collective. That's easy to say, but it's true. And I'm going to talk for a few minutes about a small part of that collective effort, a part that has to do with law, because I work in that field, and a part that has to do with the rule of law, which is one of the things I admire, of course, hardly surprising. And I know that judges cannot solve the problems that I mentioned, but still, they have a role to play. And that role arises out of the ever more international nature of the cases on our docket that I hear as part of my daily work. Those cases, not some theory, but those cases that appear before us require us, quite often, to understand foreign practices, including legal practices, as well as events that take place beyond our borders. I'd like to describe to you just a few of them, present cases that we have, and I do that because I want you to see both how law in the United States as well as the nature of our cases has changed since I was in your shoes, and it has changed, increasingly requiring us to consider the international effects of our decisions and how our law intersects with and likely influenced by legal practices beyond our borders. Since I've been a member of the court, that's a while now, the number of cases concerning foreign or international matters has grown exponentially. 20 years ago, I'd been at some exchange of judges in Europe, and I came back with this kind of enthusiasm, as I sometimes do. Spoke to an audience and professors and said, how much we'd learned. It was so interesting. And there was actually a professor from Finland who turned to me and he said, well, give me an example of something that will be useful to you in your daily work. And I said, well, I'm rather sorry he asked that. I'm sure I came up with something. But today I wouldn't have that problem. Of the 70 or so cases on our docket, I would guess about 10% to 20% do require us to look abroad. They're about commerce, they're about human rights, security, treaty interpretations, many different issues. Now consider three that we've just decided in the past couple of years that are simply illustrative. In 2012, we heard a student from Thailand who was studying in the United States. He asked his friends and families to buy textbooks in Thailand because he'd worked out, same textbook, printed in Thailand, costs a lot less. It's called the Asian edition. So he said, dear parents, send me about 500 or 600 copies, all right? And he sold them to them. And the publisher found out and thought this was not as good an idea as the student had thought and brought a lawsuit. Well, when the student received the books, he sold them. Okay, to make money.
Does our copyright law passed by Congress for America forbid what he did? Now, that technical question, to get the answer, you have to look at 5 words in the copyright statute. And anyone who could read those 5 words and immediately come up with what they're talking about gets a medal. I mean, they're 5 rather technical words, and have to do with something called back the right of first sale, which goes back to Lord Coke. And Lord Coke said the best thing ever written about it, which I can't remember, unfortunately would have helped me with the case. But nonetheless, you see the point. I mean, very ancient, not quite clear what it is. What do they mean? Does the Thai student, you say, well, he's just dealing with some question. We're the recipients, in that case, of briefs filed by the British government, French government, I think French, EU, lawyers from those countries who say what the governments tell you about the law over here, they're wrong. That's typical. That's what lawyers do. And briefs from all over the world. I said, why? This is about it. No. They said, today, your decision will affect more than $1 trillion worth of international commerce. My goodness. Why? Because copyright is not just about books. It's not even just about films and music and books. It's about everything you buy that has a label that's copyrighted, and that's almost everything. It is about computer programs, which are all over the place. It's about 50 or 100 or maybe 1,000 parts of cars. It's about everything. And that's why they filed the briefs. And we have to know, to answer that question, we have to know something about what the practices are in these other countries. Or you can't answer the question of American law properly. Now, I'd need an hour to tell you that, by which time you'd all be asleep. But trust me on that. We do have to know. Somewhat more recently, we heard a case concerning the relation of treaties to Congress's power to legislate. Can a treaty give Congress legislative power that under our Constitution, Congress would otherwise lack? It's a big question. Now, let's try that one again. Because I, in doing research on this, realized I had no idea. Professor Cassesi, who's a very good expert in Italy on this point, who knows about international organizations, says how many, he didn't put it in the form of a question, but it's a pretty good trivia question in a sense, but it's not trivia. How many organizations do you think there are internationally that have the power, to, as a practical matter, to write rules, regulations, i.e. laws, that affect more than one country? When the conversation lulls, you put that question to your friends. But the answer is well over 2,000. And if you ask how many employees are there, these are international civil servants of such organizations, busy at work, either for better or for worse, depending on your point of view, writing rules, regulations, and other things, the answer is more than 250,000. And they're out there writing laws, in effect, that you will have to follow, you see? And can Congress delegate to them legislative power? If the answer to that question is no, how are we going to solve the problems of environment, security, trade, the problems that are all over the world? But if the answer is yes, well, what happened to Congress? I mean, where did the legislative power go? I mean, that's a ticket to give away to people who are not elected all power to, not, well, I exaggerate. But you see the kind of problem, because it'll come up, if it comes up to us, in the form of, well, what's the medium position here? How do you prevent too much but not enough, etc.? You see, that's a problem that doesn't just affect us. And if you want to know that it doesn't just affect us, try the Italian courts, the German courts, other courts in the EU who have exactly the same problem in trying to trace the extent to which Germany or Italy or Austria can enter into the EU treaties without violating their constitutions. That comes up often, and they have a hard time. Well, a third, the government's power to overhear private telephone or email conversations that perhaps have to do with matters of national security, say terrorism, try espionage. The Constitution gives Congress and the President the authority to protect American security, but it gives the judiciary considerable power to protect fundamental rights. So what is the court to do when national security interests and basic individual rights conflict? The British judiciary has faced identical challenges. Now, do you get the idea? These are cases that appear on our docket frequently, not just occasionally, and they don't have good answers, and in that case, they resemble most of the cases that come up on our docket. No clear answers, very rarely. We have to consider the facts about foreign actors, foreign nations, and international relations. We have to decide how American law applies to people and to events abroad. We have to interpret our Constitution in the context of modern international security threats, and we have to undertake each of these tasks with an awareness of the fact that other courts around the world face the same questions, and that those courts can learn from each other, or at least must try to make decisions that can coexist in an increasingly interconnected world. Now, that problem I just put, the last case, raises a key question. How does the court balance national security interests and basic individual rights? Now, if you look at the history of the Supreme Court, if you look into the history of our country, which you can find there, you'd see that they answer this question over time in very different ways. Courts over time, including ours, have had different approaches. And the way that the answers have changed and their approaches change helps illustrate the changing scope of the court's power and responsibilities, and why increasingly it needs to consider facts, circumstances, and law that comes from abroad. You have to remember, if you do, or know if you didn't, that as a matter of history, our court has not always been willing to intervene in matters of national security and foreign affairs. Indeed, I think we can distinguish among 4 different approaches that over time the court has taken. For a long time in history, I think it's fair first to describe the court's initial attitude was that of Cicero. You know Cicero? I don't know why they're not teaching you Latin here. But he said, quite famous to people who either know Latin, Cicero, or something. He said, arma dicent, leges silant. That's pretty good. Mr. McCarthy, my Latin teacher, would be proud of that. But the point was, I translated that as when the cannons roar, the laws fall silent. I did that once, and somebody I actually knew got up and said, you know, the Romans didn't have cannons. I said, well, still, you see the point. I said, you see the point. At the beginning of our Civil War, President Lincoln suspended the writ of habeas corpus. His suspension of the writ, in effect, allowed his military to arrest civilians arbitrarily without any court review. On May 25, 1861, Union soldiers in Baltimore arrested John Merriman, a ringleader in this border state of anti-Northern riots. Merriman immediately asked a judge, a nearby federal court, to issue a writ of habeas corpus, despite Lincoln's action to suspend habeas corpus. At a pretty tough time, the Civil War, the judge issued the writ. He said no. That judge, by the way, happened to be Roger Taney, and I won't get into who he was, but his previous decision had been Dred Scott, which probably helped cause the war. But, so maybe he wasn't the well, we'll skip. That's the subject of another lecture. Under the Constitution, the judge explained, Congress can suspend the writ of habeas corpus in time of insurrection, but the president isn't Congress, and the president cannot suspend the writ. Lincoln did not have Merriman released. Rather, he went to Congress and defended his action. Famous, his line. He said, are all the laws but one to go unexecuted and the government itself go to pieces lest that one be violated? Famous line. No one ever knows what it means. But that's what it was. That's where it came from. His Secretary of State, echoing his sentiments, told the British minister, I can touch a bell on my right hand and order the imprisonment of a citizen of Ohio. I can touch a bell again and order the imprisonment of a citizen of New York. And no power on earth, except that of the president, can release them. Can the Queen of England do so much? Indeed, over the course of the Civil War, the president and his generals imprisoned about 13,000 civilians, often holding them without trial. President Lincoln's view is not unique. President Franklin Roosevelt's Attorney General, Francis Biddle, once said during World War II, "The Constitution has not greatly bothered any wartime president." During the war, the executive and legislative branches typically believed that the foreign threat, not the preservation of civil liberties, is the pressing problem. And for decades, the judiciary basically agreed. It would often call a matter of war or foreign affairs a political question, not suited for judicial decision, and it would refuse to intervene. Cicero would have applauded. But the courts have sometimes heard cases questioning the president's national security powers, even as applied to wars. Still, in doing so, they first began to take what I'd call a second approach to get to the same place. We'll give deference to the president. We'll hear the case, but give deference to the president. And the standard they used came close to saying the president always wins. So the president said, "That's okay. I don't mind. Decide it, as long as I always win." That's pretty much what happened. Just before and during World War II, that was the court's approach. A good case before World War II was a case that involved, and the foreign affairs experts here may know this situation, in the 30s, there was a war between Bolivia and Paraguay. I'm truly shocked that you are not ultimately familiar with it, but in any case, Bolivia and Paraguay. They fought over ownership of territory called the Chaco, a territory that they thought contained oil. In fact, it didn't, but they each thought it did. Concerned about the war, President Roosevelt asked Congress for discretionary authority to impose an arms embargo and to make the violation of the embargo, i.e. shipping arms, a federal crime. In 1934, Congress gave the president the authority he sought: impose the embargo, as long as you believe the embargo might help contribute to the reestablishment of peace. It's not much of a standard. Of course, he did believe it. He did impose the embargo. He did create a federal crime, and that was the question. See, despite the embargo, a company called Curtiss Wright sold arms to Bolivia. They tried to get them out of their airplanes, but they didn't successfully get them all out. So the Justice Department found a few and indicted them. Now, the Supreme Court at that time, this you will know, the Supreme Court at that time had struck down law after law of the New Deal for overreaching, giving the president too much power. In one way or another, they were striking down what President Roosevelt was trying to do, certainly domestically. And suddenly they upheld the power unanimously for the president to create a crime out of nothing. What's the difference? Well, said the court, foreign affairs are different. Say, domestic affairs, president can lose. Not foreign affairs, pretty tough to lose. The Constitution may grant Congress exclusive power to enact domestic laws, but it gives the president far greater power where war, treaties, and diplomatic relations are at issue. In this vast external realm, the court wrote, with its important, complicated, delicate, and manifold problems, the court said the president alone has the power to speak or listen as a representative of the nation. So look at this power. But the power has problems. It is not problem-free. Less than 10 years later, during World War II, the President Roosevelt, signed an order that sent more than 70,000 American citizens of Japanese origin away from their homes on the West Coast and held them for several years in internment camps inland. The British didn't do that. The British screened, person by person, even enemy aliens, on an individual basis. I'm not saying every person they held was a spy. They might have gotten the wrong persons, but they tried. We did the same thing in the United States with Germans and with Italians, but not with the Japanese. They just went en masse down to Tan Foran Racetrack near San Francisco, Santa Anita near Los Angeles, and they were shipped in trucks back to these internment camps. They didn't do much about it, but one did. Fred Korematsu. I've met him, actually, because our next-door neighbor in Cambridge is the daughter of his lawyer for the ACLU in San Francisco, Ernie Besig, who used to play poker with my father. All right. And so when she had Fred Korematsu staying there, I went and met him. He's a very feisty guy, and he still was at age 80. And great, I liked him very much. But he said, no, you can't do this in the United States of America. And he brought a case complaining, and that case got to the Supreme Court in 1944, long after there was any invasion threat. I can remember, 2 or 3 years old, my parents in San Francisco pulling the shades down, blackout shades, because they believed, and the Army believed, that there could be an invasion of California. But that wasn't true in 44. By 44, no one thought that the United States was going to be invaded. So what did the court do in that case? Yeah, president wins. And the people who did that on the court, Black, Douglas, Frankfurter, Rutledge. I mean, these were liberals. These are the people who decided Brown versus Board of Education not long after that. Although we think that case is obvious today, they didn't know what would happen, whether people would follow it or not in 1954. So these were the court, real liberals. From a civil liberties point of view, they decide for the government in that case. And I tried to figure out why. What were they thinking? And if I were to guess, a total guess, what were they thinking? They were probably thinking, well, someone has to run this war. It's either Roosevelt or us. And we know we can't do it. So whatever Roosevelt does, we better uphold it. Quite far, Cicero. Quite far. I mean, years later, the government apologized to the Japanese, but that's an apology. That's not the same thing as not doing it. Yes, all right. You see, you can go too far. The decision has been pretty roundly condemned. I mean, of course, it's hindsight, and I don't think it was a good decision. But there were other judges who thought differently. One of them was British, though he wrote in dissent, Lord Atkin, in a case called Liveridge versus Anderson during the war. He said, in this country, amid the clash of arms, the laws are not silent, i.e., Cicero said they were silent. They are not silent. They may be changed, but they speak the same language in war as in peace. It has always been one of the pillars of freedom, one of the principles of liberty for which we are now fighting that the judges stand between the subject and any attempted encroachments on his liberty by the executive, alert to see that any coercive action is prohibited in law. I think many American judges came to agree with Lord Atkin, at least to the extent that he rejected the theory of unchecked power articulated in the Curtis Wright case. So we see that soon after World War II, the court took another approach. Silence, president always wins. Now we have a third one. In a famous case involving President Truman, who seized the steel mills during the Korean War, the court held that the president had exceeded his constitutional powers. In 1951, the steel companies refused to meet the union's wage and benefit demands. The union threatened to strike. Mediation by government boards got nowhere. The president's cabinet told him that if there is a strike, you will find our war effort in Korea crippled. Lots of soldiers killed. So the president seized the mills in order for the government to be able to raise wages, appease the unions, maintain steel production. The seizure was not without precedent. Presidents had previously seized companies during times of emergency, say during World War II, but the companies brought a lawsuit. They said the president lacks authority for the seizure. In reply, the president's lawyers told the trial court in time of emergency just what Roosevelt had previously said. The executive's power is essentially unlimited. The judge was not persuaded. He ruled against the president, and the case went up to the Supreme Court. This time, the court agreed with the trial judge. It held the president had violated the Constitution. The court's decision might have surprised those aware of the earlier wartime precedents, but the court remembered, I think, the Japanese internment cases and their unhappy results. Justice Jackson's concurring opinion described the disastrous consequences that had followed when the law, sometimes in other nations, had given the executive unlimited emergency powers, say in Germany prior to World War II. He observed, no one, perhaps not even the president, knows the limits of the power he may seek to exert in this instance, and so he, along with the other members of the majority, held that the president exceeded his authority. He had gone too far. The court's third approach, exemplified by the steel seizure, does not establish a general rule describing how far is too far. I mean, when does it exceed the constitutional power? And it just did not consider the limits where the executive and the Congress agree, because in steel seizure they had disagreed. The fourth approach, which I can find pretty recent precedent for, has been to consider where are those limits. In 2004, 2006, 2008, the court decided 4 cases arising out of the Guantanamo detention of enemy combatants that were seized in Afghanistan and brought to Guantanamo Naval Base. The cases required the court to balance competing constitutional interests, security needs, civil liberties. I mean, what's the balance? All 4 Guantanamo cases we decided, in essence, in favor of the prisoners. We said they had access to the courts, that the military couldn't try them without certain other things, that they had to have due process, which meant decision makers who were not biased, not the, etc. They won. The first one rejected the president's claim that the habeas corpus statute meant that you can't issue a habeas corpus to somebody in Cuba. They said, this isn't Cuba, this is Guantanamo. Well, it's near Cuba. Yeah, it's part of Cuba. But there's a treaty. And the treaty gives the United States to do everything. But it says, doesn't it, in that treaty, that Cuba maintains sovereignty? Yes, but in that, the provision later on says Cuba gets Guantanamo back when we give it back to them, and not before. So the court said, it looks like part of the United States. It acts like part of the United States. It sounds like part of the United States. It is part of the United States. I parody the holdings, but you get the idea. The second case, Hamdi, rejected the government's argument that courts could not review the process, provided an individual enemy combatant. In that case, the combatant said, but I'm not an enemy combatant. I was a peaceful farmer in Afghanistan. And the military said, well, why did you have a bazooka? And he said, but everyone in Afghanistan has to. So and anyway, you see the point. There was a dispute, and how should it be decided? And we said there has to be a fair method of deciding. Hamdan, the third, rejected the government's use of special military commissions created by executive order. The fourth, Boumediene, which is probably the most important, you see, concerned an act of Congress. In Razul, we looked at the statute and said that statute gives habeas corpus the right to get into a federal court or to somebody in Guantanamo. So Congress passed another statute, and it said, no, they don't have that right. And now the question is that second statute, which says they absolutely cannot go into the Supreme Court or the other court, they're in prison, goodbye. Again, I parody it because it didn't quite use those words, but you get the point. Does it violate the Constitution? The court held it did. In doing so, the court stressed the importance of the writ of habeas corpus. It forms what Blackstone called the stable bulwark of our liberties. It protects us, as Alexander Hamilton said years ago, against arbitrary imprisonments, the most formidable instruments of tyranny. Well, those are the words. But the holding was, yeah, that's right. We're moving in that direction. They reflect a further shift away from Cicero and towards Lord Atkin. The words that I think aptly describe that case appear in Justice O'Connor's opinion in Hamdi. The Constitution, she says, does not not even in matters of national security, write the president a blank check. But now there arises a rather awkward question. If the Constitution does not write the president a blank check, what kind of a check does it write? The only answer to that question, and you're going to think I'm going to shed a lot of light on that, I just promise you I won't. But the only answer I do think has to be found through a kind of case-by-case review. That's called the method of the common law, and when in doubt, good to turn to that kind of method. Now, we will, in all likelihood, decide that kind of thing through individual cases. That's how courts often proceed. My point is simply, something of a letdown, but my point is that in deciding that kind of case, which it looks as if we're in the business of doing now, the court has to understand, if it's going to reach a sensible decision, both the security side and the civil liberties side of the equation. To do that, it has to consider activities that take place abroad, including the activities of foreign courts. And that's because other courts and legislatures facing similar circumstances may provide constructive examples that our court may be able to put to good use. We can reject them, we don't have to accept them, but we could know about them. Britain, Israel, Spain, other nations have faced similar questions. I'm not for or against, because I can't be, keep my job, but I can't be in for or against the particular results they've reached. But I do think, and I can fairly say, it's pretty useful to consider them, at least to know what they are. And that's my basic point. When we consider cases involving security and civil liberties, or international commerce, or cases arising out of treaties or statutes or the Constitution, there is no going back. We're in that business now. We will often have to consider relevant legal as well as factual circumstances arising beyond our shores. Now, you in Britain have long been aware of that fact, particularly with being part of the EU. I mean, it happens all the time. We are engaged in a common endeavor, and I make my list of cases to show you that. We face common challenges. As the court of which I am a member becomes more and more willing to address issues not only of international commerce, but also of national security and foreign affairs, it enters into that common enterprise, which is, I think, now a global conversation. And perhaps the most important outcome of that global conversation is that we learn better ways to solve transnational problems through law. Any success in this regard helps to advance the rule of law itself. Rule of law is something more than an ideological commitment. Ever since King John sat there at Runnymede and was forced to agree by his barons, we've considered a sine qua non of social existence, living together in groups of people. We're not hermits. And so we have to understand it. That's part of it. Where that rule of law doesn't exist, we lack not simply liberty, we lack security. People can't work without it. At the time of 9/11, Justice O'Connor and I were in India, about to discuss the rule of law with Indian jurists. Our very warm reception there, I mean, people, that was the day, my goodness. And the content of our meetings there made clear to us that the important divisions in the world are not geographical, racial, or religious, but between those who believe in a rule of law and those who do not. Jurists across the world help to weave this fabric. In their day-to-day work, they persist in their labors, even if, like Penelope, with her weaving, what is woven by day is sometimes unraveled during the night. Yet we continue working. We're not politicians. We're technicians. We're hopeful. We're uncertain of success. Our perseverance is important, I mean all of us, because as we recall, the rule of law is fragile, perhaps more so than we sometimes think. At the end of his book, which I think is a great book, The Plague, that Albert Camus wrote, which is a parable of the Nazi occupation of France, He writes, "The germ of the plague," which is what happened in France and Europe, that was World War II, "the germ of the plague never dies, nor does it ever disappear. It waits patiently in our bedrooms, our cellars, our file cabinets, and one day, perhaps, through the misfortune or the education of men, the plague germ will reemerge, reawaken its rats, and send them forth to die in a once happy city." The rule of law is but one defense against that plague germ, and it is one that requires constant use to prevent the arrival of that unhappy day Camus describes. It is vital to our struggle to build a humane, democratic, and just society. The interdependence of today's world creates, quite trite but true, opportunities and challenges with respect to that struggle. And it is above all the need to maintain a rule of law that should spur those of us who are interested in law, who work in those areas, should spur us on. Jurists, but citizens, ordinary citizens too, at home and abroad, to grasp those opportunities, to understand the challenges, work at meeting them together, and that's where we started this lecture. We started it today with what George Marshall wrote in 1954. "A close accord between our two countries is essential to the good of mankind in the turbulent world of today." He added that such an accord is not possible without an intimate understanding of each other. He could have written those words yesterday. The world is turbulent. Nations of diverse citizenry and diverse beliefs attempt to navigate that complicated relationship between individuals and nations and between the nations and the world. In light of that turbulence, a close accord is essential, and an intimate understanding is the only way to achieve that accord. 60 years on, the Marshall Scholarships still help us to build that accord, to open our eyes to the common enterprise that our two nations pursue. I thank you for mine.
Right, this is an opportunity for questions. Could you please state your name and please ask a question rather than make a statement? Please.
I'm Malin Fiddler, a 2014 Marshall Scholar. You mentioned that the rule of law is fragile. What would the primary challenges be that you would ask the current Marshall Scholars to work on?
Oh, you're not. I would ask the current Marshall Scholars to get everything out of these year or two here that you can. I mean, meet people, you talk to them, you make friends, you understand what they're thinking, you pursue your work. It doesn't mean you have to take everything seriously, because no one takes everything seriously. But you do remember what has a serious purpose, and that just be yourself. Now, that doesn't always work for everybody. I mean, it can be, but with most people it helps. So do what you're doing. What did I learn? I didn't learn about law in England. I don't know what I learned, but it was great.
Okay. Please, over there.
Hey, I'm Mike Norton from Arkansas, 2014 Marshall. I've asked this question to both Clarence Thomas and Sandra Day O'Connor, so I'm interested to hear what you say. If you were in another branch of government doing public service from local level to international diplomacy, besides the Supreme Court, what would it be?
What I really like in my job, I've had some number of jobs. I mean, I taught for a long time. I enjoyed that. It's fun teaching. You wouldn't necessarily know, but it is. And it keeps you young, and the students are great. But I think really the thing that was the most fun and most interesting that I did, even including my present job, I worked for about 2 years as a staff director of a Senate committee, the Senate Judiciary Committee, in 1979-80. I worked when Senator Kennedy was the chairman. And my goodness, that was interesting. I mean, every morning, to show you, every single morning, Ken Feinberg, who was like the number 1.5, I was perhaps number one on the staff. But every single morning we had breakfast with Emory Sneeden. And Emory Sneeden, a former Army general, was Senator Thurman's he was his chief of staff. Senator Thurman, for those who don't know, very conservative Republican. We had breakfast and we planned the day. And the rule was no surprises. Our object was to figure out what would be a good, as far as the introduced bills were concerned, what would make a good law, and then how can we color it politically? Red for they can vote for it, blue for we can vote, etc. And that's what the nature of compromise was, and every day was planned. And it worked. I think it worked, and Senator Kennedy thought it worked. And people looked, we had 200 nominees to confirm, President Carter had nominated. Every one of them was investigated, because they investigated the background of the person. Everyone was investigated by two people. One was Duke Short, who was Senator Thurman's person on it, and the other was first Carmine Bellino, who'd been Bobby Kennedy's investigator, and then Burt Wides, who was ours. They wrote a joint report, they signed it jointly, and the person was confirmed, almost always. And it did work pretty well at that time, but it was so interesting and such fun. I mean, I loved working for Senator Kennedy. You have no idea. He made everything exciting and fun, and he wanted accomplishment. And when later years, he told the staff, he said his father had told him that what you do is you get together a group of people, different talents, different abilities, different experiences, and help. And they help. Who do they help? They help each other. They help him. That's why they're hired. But they help others who need help. And that's how he thought. He wasn't being trite. That's what he thought. And it was fun and exciting. Okay, you have your answer, and you reminded me of that, and I really liked working in the legislature at that time. It was fun. I wouldn't do it instantly. That is, you have to have a certain experience beforehand, but I think it was great fun. Yes? Mm-hmm.
Today, I'm Hillary Hurd. I'm a 2013 Marshal. And I was just curious on your thoughts on the right to be forgotten, and if you can imagine a situation when the United States Supreme Court might recognize that right, however, if maybe in a narrower sense.
Right, the right to be forgotten is some kind of thing that you can get Google to take your name off Google. Well, we'll watch with great interest what they do abroad, and if in case it ever comes up to us, I mean, I'm being a little facetious, but you're getting a very good example of why judges so often don't talk about cases that might come up, but they haven't. And the real reason, although there are ethical reasons and so forth, the real reason is and you'll see that it happened to you too, when you're in a position to make an actual decision, things are often different from what your initial reaction is. And here we have a process for making a decision. It involves briefs, it involves complicated arguments, and you sit back and figure it out. And don't sort of pronounce on it too soon, because you don't want what you say at a cocktail party to come back at you and lead your direction when you should be deciding it there. So if you mean, am I in favor of privacy? I am. Or if you mean, am I in favor of people being able to communicate over the internet? I am. And if you want to go beyond that into the detail, I can't. Oh, very good.
My name is David Howell from the House of Lords. About a couple of years ago, the ministers of the Crown went across the road to Parliament here in Britain to seek authority to use military force against President Bashar al-Assad of Syria, who had been accused of using chemical weapons. So this was a matter of supreme high foreign policy. The Parliament refused. The Parliament rejected the demand of the government to have approval for this act. Now, without taking sides, do you think that, in any way, do you think that this had constitutional implications in this country, and do you think there were repercussions for your own constitution in the United States at this rather unusual rejection of foreign policy priorities by the elected legislature?
So you want me to say something about a matter that is, one, about a foreign country, two, that involves a decision very important in foreign affairs, and about their elected parliament. And perhaps the best reason for not saying much about it is I don't know very much about it. That is, I'm trying to think, suppose that happened where there is an implication in the United States, is something called the war power. And suppose Congress and the President get into an argument about the exercise of the war power. And does that get into the courts? Well, so far the courts have said that kind of thing, when it came up during the Vietnam War, is a political question, which we can't decide. And that's not civil liberties on one side, so that's the two branches of government. They get into an argument. It isn't our strong point to resolve arguments between, I'm not saying never, but to resolve arguments between the other two branches. It sounds logical to say, well, then the third branch should decide. They have plenty of good ways of winning those or losing those fights on their own. Somebody who gets into Congress and disagrees with them, it's amazing what Congress can do when it really wants to. And the same is true of the president. So the Constitution gives the two of those bodies tremendous authority in all kinds of ways to work their will. And what happens if they really get into an argument they can't resolve, like that kind on the war power, so far, the nation has survived without our intervening on that kind of question. Now, that's a perfectly good answer. And that's the most I can do, because I don't know the rest. Yeah.
My question is, what, if anything, stands in the way of the court ruling this summer that gay and lesbian couples in the United States have a constitutional right to marry? What, if anything, stands in the way of that?
Well, it's a case in front of us. And the only thing that I comment less about than something that's about to come up is one that's right there. We'll hear argument on that case on April the 28th. And I'd say between April the 28th and June the 31st, you are likely to have an answer to the question that you pose in some form or other.
Justice Breyer, thank you so much. My name is Jessica Mason. I'm a 2013 Marshall Scholar. The court struck down part of the Communications Decency Act, specifically talking about pornography in children, saying that the internet was such a unique medium that past decisions, like decisions saying vending machines, which were age-neutral technologies, could not dispense pornography. However, the internet was different. So my question to you is, to what extent do you think new information communication technologies are undermining the court's ability to rely on past decisions?
The cases involving all pornography, there are a bunch of cases that try to make distinctions between mere obscenity and complete pornography, or obscenity and there are a bunch of words that they use for this. But if you're talking about pornography that isn't child pornography, it's very hard to define the limits. I haven't seen something special about I'm not sure what case you're talking about, but I'm sure there is one, but it just doesn't come to mind. The internet, we have, so that's the function of briefing. We get pretty good briefs. And in the case where we did have to go into the function of the internet, they set the thing up in the library, and we went, and they were pretty good at explaining it, even for somebody like me. And one of the cases, fabulous help, was a patent case. And you had no idea what this invention was. And the lawyers got the idea of putting on the internet a demonstration. You could turn to it and you could see what the thing actually did. It was fabulous, some kind of a brake or something on a truck. So I haven't seen the interference yet. I think it's been helpful so far. Yes, Mary. Yeah.
Thank you very much, and thank you for a wonderful address, Justice Breyer. Could I ask you really what is quite a simple question? You say you give judgment in about 70 cases a year, but we know the population of the United States is 300 million or so. How do you choose the cases which you ultimately take? And how is it that we see over in this country that cases seem to come up on recurring subjects? People seem to want to push cases, and you take them for a long period of time until some happy solution is ultimately reached, it would appear.
Well, that's a very good question, because it helps you understand what the Supreme Court does. I mean, think of the probably millions and millions of cases. Every state has a system of courts and a system of laws, and then there's a federal system, and people don't realize almost all the law in the United States is state law, and we don't consider that. We don't. I mean, all family law is state law. Most criminal law, most tort law, most business law. You name it. There we are. It's state. It isn't federal, and even environment, all of education, just about. And so in Congress, they get their names in the newspaper more. But the people, I say to the students, you want to make a difference, go back into Sacramento or Hartford or somewhere. You know, I mean, it's not federal, most of it, very little. So we're only federal. And now the cases have come up and they've had a trial. Say there are trillions of disputes and some percentage of that trillion goes to lawyers and the lawyers settle almost all of it, but some they can't settle, they go to court and the courts try to settle them and they do get almost all settled and occasionally there's a trial and it doesn't settle. And then it begins to, one side wins, one side loses. The losing, I've said this only 5 million times, but the losing lawyer thinks the judge has made a mistake of law. He thinks actually the judge is an idiot, but he doesn't say that. Then the winning lawyer doesn't think about the judge. He just thinks he's a good lawyer. But still, they appeal and they keep appealing, and now they're at the level below the Supreme Court. And if you were to say there may be 8, 10 million, maybe 15 million cases in all the courts combined, those that involve federal issues and get to the level just below us of appeals is probably about 80,000, 80 to 100,000 in a year. Of those, 8,000 ask us to hear it. And we have discretion. We don't have to. We hear about 80. So we're hearing 80 out of 8,000 requests, out of maybe 80,000 possibles, out of 8 million or so in the whole country. So it's this tiny, 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 tiny point of an invisible needle. You know, so the law is being made elsewhere. But what are we doing? Well, Taft, after being president, he was Chief Justice of the Supreme Court. And he explained it best. He said, the job of the Supreme Court is not to correct errors in the lower court. They couldn't do it. Why aren't they right? We're wrong. I mean, you know, it's not the job. Everybody's had a trial. They've had an appeal. So what's the job? He said, the job is to create uniform federal law in a case where that law needs to be made uniform. So if the lower courts have come to different conclusions on the same question of federal law, we'll probably hear it. And if they've reached the same conclusion, we probably won't. Why? If they're all in agreement, why us? That's what Jackson said. He said, we are not final because we're infallible. He said, we're infallible because we're final. Now, no one knows what that means. But what really means is, well, we don't have the last word because we're so brilliant. We are brilliant, but only in the sense that someone has to have the last word. So you see, we're trying to create uniformity. So if I get a petition, and they've been gone through by law clerks, and I get a big pile, I look at the question presented. Is there a split? Is there some other reason, sometimes there is, why we have to hear this case? Because it's of great importance to have maybe Guantanamo, all right? So I'm looking at that, and we might have a case, and most of them are. Does the comma in section da-da-da of the Internal Revenue Code mean that the next word, which is for, should be interpreted as a which or a that? We had a case like that. I mean, I liked it, nobody else did. Or we could have a major case on the First Amendment, Fourth Amendment, or so you see. But now, do you understand what we're doing? And that's what, that's the criteria. And so you say, well, do the same things come over and over? They don't really come over. They don't seem to be coming over and over, but sometimes they do. But what I think sometimes they ask, well, why are you only taking 70? We could take 100, but they weren't there. But I think the reason for that, my own view why there isn't, is because there was a great revolution in the 60s and 70s, the civil rights revolution, the desegregation, lots of statutes. And the person who pointed this out best was, according to Montaigne, so you can read that in Justinian. Justinian said, I have a plan, says Montaigne. My plan is to control the judges. They're off on their own. They shouldn't just decide what they want. I will control them. They'll do what I want, not what they want. How? He says, well, all right, codes. And the codes, each one will be very definite and detailed. And it will be so detailed that they just can't go and say what they want. They'll have to follow the code. And what Montaigne says is that emperor was a real idiot. He said, he didn't say, well, anyway, because doesn't he realize
that every new word in a code is just an additional basis for lawyers to argue. And there is something to that. So now we have a health law that's thousands, many, many pages. And we have a new securities law, which is thousands of pages, filled with words, a lawyer's delight. And I suspect, though I can't prove it yet, that 3 or 4 or 5 or 6 years later, the cases start coming up because they're tough cases, I'm sure, that arise out of those words, and different judges will decide them differently, and before you know it, we'll have the conflict, and then we'll be brought into it. Does that describe, you say, that's what we think we're doing? All right?
I think we need to bring this to an end now. I'm delighted to say, as somebody who's married to a lawyer, that I've now decided the true definition of what delights lawyers: thousands of words. Thank you very much indeed. Thank you.